Over the past weeks, there has been issues surrounding attempts to remove Chief Justice Gertrude Torkornoo. Well, she's been suspended, but a number of Ghanaians seem to be interested in the issue. They've raised issues about unconstitutionality. Otafo Member of Parliament, he's been to the Supreme Court. He's tried injuncting the process, but that was unsuccessful. A new twist to this is that her ladyship herself, she has filed a case at the Supreme Court, and she's been represented by former Attorney General Godfred. We're in the offices of the former Attorney General to speak to him on this and other issues emerging out of the attempt to remove the Chief Justice. You're welcome to Channel 1 TV.
Thank you very much.
It's been 4 months after the NPP lost the election. A lot of the NPP folk we know said it was a difficult defeat, a moment for them. How was it for you?
Well, I think this is not the first time we have been in opposition. We were in power from 2001 to 2009, and we're in opposition. And some of us, we had our law practice. Our law practice thrived and all. So for me, the only change is, of course, the office that I hold. But in terms of law practice, it's business as usual. Because the office of Attorney General, for me, was a professional office in a way. Even though the Attorney General wears two hats, Minister of Justice, by virtue of which he sits in cabinet. The primary functions of the Attorney General essentially are law related, to be the Minister of Law and ensure that there's efficient administration of justice in the country. So I enjoyed it, and I still enjoy law practice, just as I did before I went into government.
So the switch wasn't difficult. I mean, taking your books, coming back, going to court, and now being on the defense side rather than being on prosecution.
Oh, definitely not. I mean, as I've said before, we all knew it was not a permanent office. Yeah, we as Attorney General, yes, we're Attorney General, and it cannot be Attorney General for life. So, yes, the only difference is the kind of service that was rendered. That was public service. And now it is private law practice. And so I can charge you fees even for speaking to me. But of course I will not.
Now, that means partners. It should be new, right? A lot of people knew you from your days at Akufo-Addo Prempeh and Co. Is Damian Partners new, or it's been there while you were still at Akufo-Addo Prempeh?
So interestingly, Damian Partners has been incorporated since 2017. Wow. I was at Akufo-Addo Prempeh and Co. Started from 3rd October 2020, 2003. And then by 2017, after 14 years of practice with the Akufo-Addo Prempeh and Co., I felt that it was time to move on and establish my own law firm. So indeed, in January 2017, I incorporated Damian Partners with a view to moving into private practice from a different chamber. That's my own chamber.
Oh, so this is not a post-2024 thought?
Definitely not. The documents of incorporation are there. I formed it in 2017, but consistent with my virtues, I decided to keep it on ice, essentially. I did not have the law firm activated because right after I incorporated, the president nominated me as Deputy Attorney General. So I said, well, I did not want a situation where there will be conflict of interest, whereby my law firm may be engaged in cases and people will say that I'm assigning cases from the office of Attorney General to my law firm and that kind of thing. So I just decided to just keep it on ice. There was no practice at all. So right after we lost power, not after we lost power, right after we officially exited office, I revived the office. And so within no time, about a month or so, I took a month's rest. Thereafter, I obtained my solicitor's license, chamber registration license, and then the law firm started.
How has it been so far? I mean, running your own private practice?
Well, it's been interesting. It's been good. You have the freedom of choice in terms of selection of clients and all. Of course, I do a lot of pro bono work as well, as I used to do and all. And so, of course, we also have to keep body and soul together. So there's a lot of commercial practice as well.
Anybody who knows you would be fair to say that the modus operandi really has not changed that much, because NPP in opposition, you will take a lot of constitutional cases to court. The Ejechum and the rest, you were involved in those cases. But is it fair to say that this is the biggest case as of now for Damian Partners?
I mean, as you yourself indicated, I've been familiar with these kinds of cases. I remember the very first prosecution of the MPP ex-government officials in 2009. The then former Foreign Minister, Kwesi Oseje. That trial was conducted by me, successfully so. He was charged with 8 counts of willfully causing financial loss, breach of procurement law, and abuse of office of profit and all that. And I succeeded in acquitting him. Thereafter, I did quite a number of matters. I acted for various people, including the president himself, Nana Addo Dankwa Akufo-Addo. I was his lawyer in various matters, the action challenging whether he was a lawyer or not, by Justice Pega, as well as other matters. And if you are there, so I'm used to that. In terms of Damian Partners, yes, we have been handling the matter of the dismissal of public sector workers who were dismissed from the public service some time ago. And then we took on this challenge. Constitutional cases are really not new to me. And I believe that is why the lady Chief Justice, perhaps in recognition of my humble expertise in that regard, decided to call on me to assist. And of course, it's something that I've always been speaking about, independence of the judiciary and all that. So I had no difficulty at all lending my assistance.
We'll come back to what people have been saying about your involvement and whether it is good for the case or not. But did this case find you, or you found it? I mean, we know that the OTAF member of parliament, he went to the Supreme Court even before the CJ engaging you. Did you have an idea of taking up the matter, or he approached you?
No, so yes, he approached me. I mean, Vincent Eko Asafua, that he was really concerned about the happenings in the country, the attempt, overt, I mean, as it was, to remove the Chief Justice from office, and that he found unconstitutional. And I looked at the provisions of the Constitution, and I examined the relevant best practice internationally, and I recognized that clearly what is happening in the country betrayed a litany of constitutional violations and all, and therefore it was appropriate that we took up the challenge, which we did, and which is still pending before the court. It's not over. It is only the injunction which has been dismissed. So before that sitting of case already, next week we'll be setting out the issues for intervention by the court, and then we'll have the court hear the matter on its merit.
Is it a matter that you seem to have taken an entitled and unentrained position to say that everything about the processes to remove the Chief Justice is unconstitutional? Because from the beginning, when the president says he's consulting the Council of State, that's when you started raising issues about unconstitutionality with the process till date to the formation of the committee, and even objecting to some members of the committee. It looked like every step of the way you want to find a problem.
I mean, it cannot be an entrenched position at all. The point is that we have a constitution, we have the letter of the Constitution, and we have the spirit of the Constitution, which essentially sets out the rationale behind the various provisions that we have there, and how they ought to work out in a way as to achieve a proper functioning of the society. And it's also interesting to note that when I was in office as Attorney General, I actually started the process of enacting regulations to govern the operation of Article 146. It is something that is in the office of Attorney General. The director of the legislative drafting will have it. The current Attorney General, I'm sure, if he's interested, will have it and will know. So,
what started?
Yeah, because the process of enactment of legislation, whether subsidiary or primary, goes through a process. It has to go through stakeholder consultation. In the first place, we actually received a letter from the Judicial Council. Yeah, the then Chief Justice wrote asking us to commence the process of enacting regulations to govern Article 146 and all. We did a full draft. I have a copy that I can even share with you. Subsequently, we set it for stakeholder consultations, which is eliciting the views of various stakeholders, the Judicial Council, maybe the Ghana Bar Association, the Junior Legal Council, and all as to it. It is after that the legislation could be laid in Parliament. And we could not complete that, and then the elections came. So it is there to be continued.
Now, let's talk about the current case as we have it, the issue with which you are representing the suspended Chief Justice. A lot of people seem to find the views you're pushing in that rate interesting. The first one has to do with the demand for the hearings to be public. People say that it's an open and closed book. 1468 says all proceedings should be in camera.
So I think it's important to indicate that, number one, this is the very first time a Chief Justice has had to issue a writ in the courts of Ghana. Has never happened. And that's because the Supreme Court has always been the bulwark of the protection of the independence of the judiciary. And clearly, any time there's been an attempt to remove a Chief Justice in the history of the country, the Supreme Court has had to intervene. And that intervention is on account of the fact that there ought not to be any interference whatsoever by any person or authority in the administration of that or in the independence of the judiciary. And so what is happening is quite interesting. I would say that whenever there has been an attempt to undermine our democracy, it has always begun with an attack on the judiciary. Like I cite the example of the First Republic. In 1963, there was the removal of 3 Supreme Court judges, in fact, the dismissal of 3 Supreme Court judges, including the Chief Justice, Sayako Kosa. Within a few years down the line, there was chaos, and then there was a coup d'etat, because it was felt that if the primary institution, which will be the bulwark for protection of rights in the country and for ensuring that whenever the executive wants to overreach its powers, it is brought in check, has been interfered with, then there's no hope at all for the society. In 1969, when there was a mass dismissal of public sector workers, they called Apollo 571 or so, the Salah Natanjira case and all, the Supreme Court ruled in favor of the dismissed workers, and essentially, and the Wizard government was compelled to comply, but the then Prime Minister made a famous remarks that no government can compel employment of workers. A year thereafter, 1972, there was a coup d'etat. In 1979, 1980, there was an attempt to remove the Chief Justice. The Chief Justice was subjected to parliamentary vetting, even though the Constitution, the letter and spirit of the Constitution, the spirit in particular, because the Constitution was a little bit ambiguous in terms of the specific prescriptions as to whether a Chief Justice who held on from the military, the ex-military regime, should continue as Chief Justice. But the Supreme Court interpreted it to mean that clearly, yes, such a person was still a Chief Justice and should not be subjected to parliamentary vetting. The Chief Justice had been subjected to parliamentary vetting. He also, in compliance with it, even though he did so under protest, subjected himself to vetting and then was failed. And clearly, it means he was supposed to leave office. The Supreme Court intervened and said no. But that attempt to interfere in the judiciary is significant because a year later, there was another coup d'etat.
From the narration.
Yes. And then after 81, the gravest assault on the independence of the judiciary in Ghana was witnessed. 3 high court judges were picked up in the middle of the night and brutally assassinated. They were murdered in cold blood. It has ruined the scar on the conscience of the nation. And I think that these developments are very worrying, and therefore when there's any attempt which clearly is unjustified to remove the Chief Justice, it ought to be brought in check. And we find a government which has come into office on account of a rhetoric showing an inclination to deal with the judiciary, that the judiciary is biased and they're going to clean it up, they're going to reset it, and they need a new Chief Justice, and the new Chief Justice will help the nation better and all that. And so they come to office with such rhetoric, and then they embark on systematic patterns of conduct to give effect to that which is abhorred by the Constitution. I'm saying that the rhetoric that they engage in, the kind of comments that were made by President Mahama, were clearly the kind of sentiments that is constitution of the country aboard. The Constitution clearly, explicitly, in Article 127, Clause 1 and 2, prohibits interference with the independence of the judiciary by Parliament, by the President, or by any person or authority at all. And so if a person comes to office as President and comes with a narrative that he's going to change the judiciary, he's going to deal with, we need a new Chief Justice and all, and such rhetoric is repeated by key members of his government. We've seen Asidi Nketia make such comments, Mr. Fagbande clearly said the Chief Justice has to go and all that. Now you see that, no doubt, we ought to be concerned about what is going on. So, and they know that they cannot achieve that except when they put or cook up certain sets of theory to suggest that the Chief Justice is unfit to occupy office and all that. I mean, so what do? They end up with all these spurious allegations. And if there's anything that this Chief Justice has stood for, it is her integrity. All those who have seen her work both in her previous private law practice since 1986, 39 years. I'm sure that 39 is even more than your age. Yes, that's the length of career that she's had as a lawyer, 39 years. And then as a judge of the Superior Court since about 2002 or 2003 or so. I mean, so all those who have followed her will notice that if there's anything that she's noted for, it's her integrity. And therefore, it becomes very puzzling and that they would want to bring her down on account of the one thing that she stood for, her integrity, by suggesting that she spent some money unlawfully on her holidays. The holidays are part of her official package, is it not?
The argument is that the president really has no option in this. A petition has been sent to him. He's consulted the Council of State. The Council of State says yes, let the Chief Justice answer. He's further consulted and they say let her step aside while the committee goes ahead to investigate, the 5-member committee, including 2 of her own peers. The question people ask is that what really is President Mahama doing wrong? No,
I mean, absolutely. 2 major points of error on the part of President Mahama. Perhaps not error, but I mean, wrong. I don't know whether it's deliberate or not. First and foremost, the receipt of the petition. He received 2 petitions in February, kept it to himself, engaged in consultations with the Council of State until the end of March, when he informed the general public, without even informing the Chief Justice. So the Chief Justice goes to work after having worked for God knows how long, and then one day wakes up to the news in the newspapers that President Mahama has engaged in, or started engaging in consultations with the Council of State on account of 2 petitions which were received 6 weeks before. That must be of concern, and clearly it is unconstitutional. The second point of grave constitutional violation is the determination of the prima facie case. That is entirely within his authority. It is not, so you cannot say that President Mahama has not done anything wrong and he's only a conveyor belt. That is no business of being a conveyor belt.
Could he have said no to the Council of State when they said a prima facie has been established?
It is not for the Council of State to make the prima facie determination. It's actually for the President. The Constitution enjoins the President in consultation with the Council of State to make the determination. So the duty to undertake the exercise is the President, and he does so in consultation with the Council of State. And I'm saying that in doing so, you ought to make a judicious determination. When we say judicious determination, it means that you look at it critically against the evidence before you and determine whether indeed there's a case of misconduct. And misconduct, to remove a judge on the ground of misconduct in all other jurisdictions, is no mean exercise. And you cannot say that on account of having exercised her right to a holiday package that is guaranteed her under Article 71 of the Constitution, there's basis for misconduct. I mean, and the most grave violation is when he refuses or he fails to give a reasoned ruling. So the prima facie determination that I have seen and which I have attached in my processes before the Supreme Court was just simple. That the Council of State has been consulted on the petition before you. The Council of State is of the view that there's a case for you to answer in spite of the 3 petitions. And
that's only that?
That is the only, yes, it's all before the court.
You think he should have gone ahead to analyze the petitions and the response from the Chief Justice and giving reasons why he think that despite their responses, she still has to answer?
That's the requirement of the law. That's the requirement of the law. I mean, the law requires him to undertake a prima facie determination. That process is a quasi-judicial one. It requires a careful evaluation of the petition. That is why there's also even a requirement for you to notify the other side before. And then the other side also has to provide a comment to analyze both the petition against the responses and make a careful determination and provide the reasons.
But the fact that the reasons...
You cannot lump up the three petitions together and say there's a case to answer in respect to the three petitions. Which of the petitions? Which of the specific allegations contained in which of them? And what are the specific reasons? What are the ones that there was no case to answer? So clearly there was no proper facie determination.
So this is one of the reasons the Chief Justice herself has gone to the Supreme Court.
Yes. That's one, together with the contention that, you see, and I think we must, stop being hypocritical in the country. And we must have a regard for due process. This is the head of the Ghana's judiciary being purportedly subjected to proceedings for her removal. She has not been given a copy, or she had not at that time been given a copy of the petition until she requested for the petition. She has not been given reasons for the prima facie determination by the president. And then members of the government are out on radio, TV, and internet talking about the petition and how it was bad that the Chief Justice used her money for her husband, state money for, and all that. So the essence of the petition is actually out there. You have seen the contents of the petition out there. You have seen what purports to be her responses. I don't know whether they were her responses, because indeed she has not shared them with anybody at all. And so everything...
She might have shared with you.
No, because my duty now is to challenge the constitutionality of the process. It's not about...
So you're not representing her before the committee?
I think, let me just make the point before we digress. So the point I make is that everything about this petition has been put out in the public domain already. And the Chief Justice has been damnified, has been condemned, and all by leading members of the government and all that. And when it comes to her, her side of the case, opportunity for her to state her side of the case, then the state requires that it should be in camera, it should be in secrecy. It cannot be in secrecy. There ought to be light on the proceedings, because she has already been damaged, the public domain and all that, and everything is and I think that the most effective weapon in all of this is to shed light on the proceedings. What's the warrant for secret proceedings when indeed everything has been discussed every week? I'm sure your station definitely has discussed the petition. You've discussed it on your Saturday programs and all that, and the content and the analysis here and there. And then when it comes to her, for her to state her side of the case, you said it should be in the dark.
Proponent of this view says the obstacle is in Article 1468.
It is not. That is why we brought a case for interpretation of the Constitution. And that is why I also speak on the spirit of the Constitution. In many cases, the history of the country, to foreign attention, and many other matters, you find the Supreme Court, even Ajaytum that you referenced earlier on. And indeed, I was not in Ajaytum as counsel. It was another Ashanti too. The Supreme Court has had to read certain words into the Constitution when necessary. So the basic rule of interpretation is that you give effect to the plain words of the Constitution if it is clear and if it serves the purpose of the provision. But where the plain words of the provision will lead to ambiguity, absurdity, or will lead to irrationality, then the Supreme Court will look at the purpose of the provision, and that's what we call the purposive interpretation, and read meanings into it to give effect to it. And I'm saying that if you look at the Constitution as a whole, starting from the provisions on fair trial in Article 19, we talk about Article 19 clauses 13 and 14, which talks about adjudicating authority. That is not a court. It is in reference to such adjudicating authorities. Then you go to commissions of inquiry in Article 278 onwards. Article 281 specifically enjoins that proceedings of a commission of inquiry ought to be in public. And Article 295 constitutes commission of inquiry to include a committee of inquiry. So in my view, except where the concerns of public safety, public morality, public order will require, proceedings of any adjudicating authority ought to be open to the public, especially when it is set up or is done under the Constitution. And in this case, these provisions are, or these proceedings are being conducted pursuant to Article 146 of the Constitution. And I'm saying that there's nothing which threatens public harm, public order, or public safety in these proceedings, such as to warrant that it should be in the dark or it should be in camera. On the contrary, we think that the conduct of the government so far, together with what has been witnessed in the whole of the proceedings, will rather require that it ought to be in public, because it is only on account of that proper justice and fairness can be served.
Now, apart in addition to the reliefs, is a relief for that warrant that was signed by the president that accompanied the prima facie determination to be revoked. On what grounds are you making this?
I think just, primarily, if really proceedings are conducted on account of a false basis, if the basis for the formation of the committee is an unconstitutional act by the president, which is that the determination of what he purports to be a prima facie case does not exist at all, then clearly it is null and void, and the warrant of suspension ought to be suspended, because that warrant of suspension was issued in consequence of what the president represented to the nation as the determination of a prima facie case. And I'm saying that prima facie determination was none at all, was null and void, because it was not done in accordance with the dictates of the Constitution. And on account of that, it ought to be set aside.
Let's take the objection to members of the committee. For Justice Scott Pullman, the point you make in that suit is that he has given favorable judgments to one of the petitioners. How does that rise to the level of he not being able to be part and chair the committee?
I think, and we make that case not out of any, without prejudice to the relations I have with Justice Pullman. I've known him for quite some time. I like him a lot, not for any reason, but the mere fact that, yes, he was actually even a chairman of the Council for Law Reporting when I was at NGO. So I've had very good relations with him and all that. So I do that not because of any feelings at all or towards him, but just because of the principle. If the Chief Justice is being removed from office on account of a matter that she conducted in the Supreme Court, which is the Akogo matter involving the policeman. The policeman complained because of that matter, that the Chief Justice made some comments and all that. And indeed, Justice Pullman was part of the panel. And everything that was done by the court. So on what account do you single one member of the court out for removal because of what was done in the matter? And then you make another member of the same panel president or chairman over a committee set up to inquire into the conduct of the Chief Justice. I think that clearly it cannot be right. Even in the courts of Ghana, when the matter is said by a judge at the High Court, and the judge has been promoted subsequently to the Court of Appeal, and the matter comes up for hearing at the Court of Appeal, the judge will not sit on the matter. If the case is accidentally placed before a panel, including that same judge, then the same judge will just wash his hands off. So we think that the formation of that committee was wrong. Apart from that Akogo matter, Justice Pullman also gave 4 judgments in favor of one of the petitioners, again, the same Daniel Ofori, who on which panel the Chief Justice also served. So it cannot be right. I think this is simple.
Do you think that there might be a problem with the judgments is delivered for Daniel Ofori, or is just a matter of saying because he's presided over cases that involve Daniel Ofori, then he cannot be part of a committee investigating a petition brought by Daniel Ofori?
It goes without saying that if a judgment was given by Justice Pullman, in this case it was not just one judgment, but about 3 or 4 judgments in favor of the same person, and matters relating to the matter are the subject matter of a petition. he cannot be on the panel. He goes without saying. I don't think it's something for us to find difficult to accept. And again, if he was part of a panel of another case, the Akogo matter, and Akogo says that on account of how the court treated him, the Chief Justice says that, well, everything was done by the court. There was no single ruling by her or separate ruling by her as a judge. It was ruling by the court and all that. How can a member of that panel be selected to sit on it? It's a no-brainer, really.
Justice Adibu said he was selected by the suspended Chief Justice to preside over the injunction application that you had at the court. And based on that, you say he cannot be a member?
Yes, because for me, it has far-reaching implications for the independence of the judiciary. Because it means that whenever the president wants to frustrate the hearing of a matter, all the president will have to do is just to appoint a judge to serve on a committee set up in the ministry. So most of the time, the Attorney General has cases in court because there are many cases involving ministries, departments, and all that. If even a minister feels that the judge is not going to be inclined towards him or her, all the minister has to do is to set up a committee and appoint the judge onto it. And I think that in this case was improper. But as I said, who had been empaneled to sit on the matter had actually sat. The matter had been adjourned on 2 occasions. And then the next time, he was lifted from the panel and put on this other committee, which had been set up to investigate or probe or inquire into the conduct of the Chief Justice.
But what do you say to those who say that the suspended Chief Justice is happy to failed Justice Seidu at the Supreme Court to hear a matter that could prematurely halt the entire proceedings, but she has a problem with him hearing the petitions to its end?
No, I mean every litigant in court has a right to challenge any aspect of the proceedings that are deemed illegal or offensive to due process or procedure or even to the Constitution. And in this case, I'm saying that there have been very grave violations of the Chief Justice's constitutional right. And it's also not a matter, the violations are not of such a nature as to affect only her. It has a direct effect on the integrity of the judiciary, the independence of the judiciary. And we think that we have the view that in order to avoid such occurrences, there ought to be a proper judicial intervention to deal with them.
For the other 3 members, you objected to their qualification to be on that committee as well?
Oh, yes, because we have clear evidence that they've not taken the oath. They should have taken the oath of office before being properly vested with the power to adjudicate, because it's a quasi-judicial proceeding. It's something for the court to determine all of this.
It has nothing to do with whether they are lawyers, they are not lawyers, they are not members of parliament, not members of cabinet. They meet that bill, but they did not take their oath of office to be able to be part of the committee.
So our query is in relation to the failure to take the oath of office. So that let them to interest you. When his matter came up in the Supreme Court, the Chief Justice actually voted in favor of Daniel Domeville. So really, I mean, as I always say, that all these attempts by the NDC to remove the Chief Justice and all are unjustified. The attempt by the NDC to take control of the judiciary, I have never done that at all.
Can anybody take control of the judiciary?
That's essential, but that's the kind of rhetoric that was engaged in by President Mahama. That's the kind of thing, yes, that when he comes to power, the NDC lawyers must hold themselves up in readiness, that he will be appointing them to the bench because the bench is dominated by MPP and all that. That's exactly what is abhorred and prohibited by the Constitution. It's a very serious matter. And he's seeking to give effect to that thing which is prohibited by the Constitution. And I'm saying that he could only have done so by cooking up all these allegations against the Chief Justice.
Do you believe this is overriding consideration?
Precisely, 100%. I mean, it goes without saying. And throughout the proceedings, the NDC people have made statements to that effect. Mustafa Bande and other people, Rashid Tanko and Asid Nketia, they have said that, this year.
Some have questioned why you are so vested in this case. And they think that as a former Attorney General, as a member of the New Patriotic Party, at best you should distance yourself from this case, and the Chief Justice ought not to have even engaged you.
I think the Chief Justice has the right to choose counsel, and she does so taking into account the specific matter that she wants to take to the Supreme Court, assessment of the expertise of the lawyers and what have you. It's a basic right that is open to all. But I think the record too ought to reflect the fact that if there's any attorney general who has spoken against interferences with the independence of the judiciary, it is me. Right from day one, when I was appointed attorney general in 2021, my maiden bar conference, I gave a speech at Bogatanga, as deploring the unjustified attacks on the judiciary and all. And it continued. My bar conference at Who, I actually took a shot at President Mahama for suggesting that the judiciary ought to be cleaned up and that he was going to change the judiciary and NDC lawyers to be appointed and all that. And that, so if we critically take a look at it, the source of all the problems that the NDC people have with me, it is my defense of the judiciary. The source of the problems that the NDC lawyers all the time have with me is actually that speech by me at the bar conference in Ho in 2022, when I went all out to condemn, certain terms, the kind of comments that had been made by President Mama. So what I'm doing now is very much consistent with what I've stood for all along. And even when I was in private practice before I came into public service and all that, I used to stand up for the judiciary. And you would never find me on any occasion attacking a judge. Never at all. So last 2 weeks in the Supreme Court, I actually made a point that was actually the very first time I was objecting to any judge. That is when
objected to the acting Chief Justice.
Yes, because of the specific circumstances of the matter. I am one judge and one lawyer who on every occasion has always recognized and sought to uphold the dignity and authority of the court at all times. And so whenever there's any attempt to encroach a territory that actually should be cordoned off, I would definitely speak against it. That's what to do. And I'm saying that when they do so, it has a far-reaching effect on the democracy that we practice. Ghana's democratic credentials will really, really go down if the Chief Justice is removed.
When you suspect that the attempt to remove the Chief Justice is politically motivated, as you've alluded to, there are those who are saying that you're stoking more fire into it by being a politically exposed person. I mean, the Chief Justice could have found a lot of dummies out there who also are interested in the independence of the judiciary. But why this dummy who is a member of the NPP?
But I think the point also ought to be noted that all the counsel for the petitioners are all politicians and politically exposed persons. Chachuchi Kata, nobody can be more of a politician than Chachuchi Kata. President Mahama's lawyer in the 2020 presidential election petition, and who subsequently became lawyer for Daniel Ofori in the court, and the same Daniel Ofori turns out to be the petitioner against the Chief Justice, and that same person who was President Mahama's lawyer now is the lawyer trying to prosecute the Chief Justice before the Committee of Inquiry. It's very, very serious. The President's lawyer, Chachuchi Kata, is the one who is leading the assault against the Chief Justice. And then Saido Sori, lawyer for the Speaker of Parliament, Aban Bagbin, also leading the charge against the Chief Justice. So you see two arms of government, the executive and the legislature, their respective counsel are the ones going against the Chief Justice. And then you find Baka Famo, also who worked in President Mahama's office and did all kinds of activities against the NPP government, clearly politically exposed, also part of the team. So if there's any group of people who have actually politicized this process, it's the NDC. And I do not think that my entry into it changes the story at all, because as far as I'm concerned, my record of defending the judiciary and standing up for the independence of the judiciary and deploring unjustified interferences with that independence, which is assured by the Constitution, is there for all to see. And my record of conducting constitutional cases and all that is also there for all to see. So I think that all these statements more or less are a distraction. the court ought to look at the merits, or the public ought to examine. Public ought to examine the merits of what the Chief Justice has put before the Supreme Court, and let the Supreme Court decide.
Can you win this war? Public commentary we've heard is that the Chief Justice is gonna. There are those who are saying that she should actually even resign and save us all of this drama.
Save you drama, resign for the democracy to be eroded. And I think that the surest way of eroding the democratic credentials the nation has is for the public to subscribe to attacks against the Chief Justice, who is the head of the judiciary. The surest way of ensuring that Ghana's democratic credentials are destroyed is for the public to support any attack by the president and his government to destroy the judiciary, or to take hold, as they want to say, of the judiciary. It cannot be at all. The judiciary is actually one arm of government which essentially, for want of better expression, should be cordoned off and protected against any attacks on its independence. And that is what we stand for.
Now, the case that you filed for the suspended Chief Justice, have you heard back from the court on when you're supposed to go to court when hearings?
Well, the application for the interlocutory injunction has been fixed for Wednesday, 28th of May.
Wednesday, 28th of May.
Yes.
The other issue also has to do with the perception that the judiciary has been unfair to the NDC. On one occasion, actually, the minister in charge of government communication, he gave an indication that he thinks that the judiciary has been unfair towards the NDC. Since 1992, he makes mention of cases like J.H. Mensah versus the Attorney General and all those cases that they've lost. And even in the time when you were Attorney General, they've been a chorus of the Supreme Court being a unanimous FC. People think that this perception really also adds up to reasons why people may want the Chief Justice out. So
people seek to mock the court of Ghana, and then we must all subscribe to it. Or after mocking the court of Ghana, we must do exactly what they want, because we want to give effect to the kind of narrative that they want to churn out. I think that such comments clearly are unjustified, misleading, and with all respect, ignorant. Unanimous decisions are given by the courts every day. Indeed, just 2 days before, 2 days ago, on Tuesday, I was in the Supreme Court on my matter. There was a unanimous ruling in my favor, and a panel constituted by Justice Bafuboni, Tanko, Kulendi, Dakwasari, and I think Kofi. There have been various decisions that have also been unanimous that have gone against the government, or that went against the government when I was in office as Attorney General. The Domlevo matter, I think, was unanimous against the government. The challenge of the the COVID-19 law was also unanimous and was against the government. So the point must be made that the judiciary ought not to be controlled. The fact that a decision is unanimous, that you do not like, that means that they must stop giving unanimous decisions. Indeed, recently, the same day that the Supreme Court gave the 3-2 ruling, earlier on they had given a ruling which was also unanimous against me. You've never heard me criticize the judiciary for giving a ruling. When the decision on the interlocutory injunction was dismissed, I never criticized the judiciary. I would disagree with it, which is my right, because there's freedom of expression, or freedom of thought in the country, and all that. I would disagree with it, but that's my view, that's where it should end. So I think we ought not to give credence to such views.
Now, May 28th, you're going back to court. Have you spoken with the suspended Chief Justice? Has she taken all this personally? And has she shared her views with you on how, whether it's taking a toll on her or not?
Well, she's a very strong woman. She's one of the strongest women I've ever seen. And indeed, she said two things. She said, number one, she was reflecting on the word of God. She's a very strong believer in the word of God. And then she remembered that, yes, David was even able to defeat a Goliath. That, yes, David was able to just use a very supposedly innocuous subject to defeat a Goliath. And so there's always hope She finds confidence and trust in the word of God, and she knows that the truth will come out. That is why she wants light to be shed on the proceedings. That is why she wants a public hearing for the public to hear her case. She has kept quiet so far, never made any comment at all, whilst people disparage her and damnify her and all that. She's waiting for the day to speak, and it must be, as is usually the case under the Constitution, a public hearing. 2, she also said that she remembered, in the times of her reflection on the word of God, she actually remembered that even the most powerful man in the free world, Bill Clinton, at that time had an impeachment trial. Bill Clinton went through an impeachment trial, and that was the person who was supposedly the president of the United States of America, the most powerful person, leader of the free world and all that. And at the end of the day, she also have a day and all that. So she's very calm, reflecting on the word of God, and she knows that the truth will surely come out, except when they seek to suppress the truth in darkness, which is what she will resist.
Finally, what would you say to persons who may believe in your views but seem to be mute at this particular moment?
I think that it's important that good men in society stand up, or it's very important that we all stand up for what is right and what is virtuous. There's never been a time that there has been such a grave assault on the independence of the judiciary in the Fourth Republic as what we see now. An unbridled desire to get rid of the head of the judiciary. And also, you see what they're doing, appointing 7 judges at a go to the Supreme Court to make the numbers 20. Clearly, they want to take control of this. I don't know what control means, because the same judges that they claimed were biased when Akufo-Addo was in government, and the judges also ruling in their favor, now they don't say the judges are biased. So there's a lot of contradictions in the conduct of the NDC. They do what the young people will say, gaslight. Exactly what they are doing, they say, oh, you rather doing. And they will have a way of ensuring that you actually believe that you are doing the same thing, even though you are not doing the same thing. After the 7 judges that have been promoted, they make allegations that junior judges were promoted by Akufo-Addo and all that, and the chief justice was not the most senior on the court and all that. But that has never been the law of this country. After the 7 judges that have been promoted, many of them are junior on the Court of Appeal. Some of them were even appointed to the Court of Appeal by President Akufo-Addo a year or 2 ago. They have been sent to the Supreme Court now. Some were appointed 3 years ago. Many of them were actually sworn in my tenure as Attorney General. They've been sent to the Supreme Court now. So what is the justification for saying that, or for making all those allegations against Akufo-Addo? So you see, there's a lot of contradictions, hypocrisy, and bad faith in the actions of this government. And I think that